Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to talk about a case that I hate. And this is a foundational case. It's a really important case. Everybody in law school gets taught this case. Every criminal lawyer is going to know this case. And I hate it. I think it is a badly decided case. I think it's an illustration of the Supreme Court going wrong. And because I hate this case so much, I am going to be enjoying a beer while I do this video because I hate this case. I don't think I can really understate that. So let's go through and have a look at this case. It is the case of the Queen and Jobidon. Now, it starts out with a statement of facts. I'll just note that as a general sort of truism in the legal sphere, people say hard cases make bad law. And what that means is that where a case sort of cries out for a particular result, and often where we really want to punish somebody because we think they're a bad person or that something tragic has happened, often that can lead the court to coming up with principles that are not the best in order to justify reaching the conclusion of punishing that person. In my view, that's what seems to have happened in Jobidon, and ultimately the result of that is it carries further down the road. It's not just limited to this case, because this is a major case. It's one that gets cited for all sorts of things. So, statement of facts. The appellant, Jules Jobidon, was charged with manslaughter for the unlawful act of killing Rodney Haggart through the offense of assault, alternatively through an act of criminal negligence. So what they're saying here is that, manslaughter as an offense involves that you've killed somebody, but that it involved some sort of criminal act in doing so. It's actually not, you're not going to be charged with manslaughter if you killed somebody only through legal actions, which is kind of hard to do, but you can think of situations where this might happen. For instance, if you're a doctor and you're trying to perform heart surgery, that heart surgery is legal. And, if you make a mistake, but you're not criminally negligent in making that mistake, you may have accidentally killed somebody, but it's not going to be manslaughter. So that's an example of how you might, kill somebody without it being manslaughter. Similarly, if you were driving late at night and somebody who was really depressed ran out in front of your car, from behind a bush, they'd been hiding there intentionally doing so, you may have killed them by running them over, but it's not likely to be manslaughter if you're in a situation where that person has essentially prevented you from doing anything else, and so you're not negligent or anything like that. So manslaughter requires that unlawful act. So here they're saying that the unlawful act was committing an assault or by being negligent in some fashion. Let's go on and I'll explain a bit more about how that's happening. So the incident leading to the charge was a fist fight between the two men in a parking lot outside a hotel near Sudbury, Ontario on September 19th, 1986. So long time ago, in legal terms at least, but this case continues to resonate. At the date of the killing, Rodney Haggart was 25 years old. He had consumed some beer. His blood alcohol level, measured a few hours after the incident, was 160 milligrams of alcohol per 100 milliliters of blood, but the trial judge found that Haggart appeared perfectly fine and perfectly normal. Now, I'll just note here, the limit for driving is 80 milligrams of alcohol per 100 milliliters of blood. So he's at double that. In Canada, that actually triggers additional, that's considered a statutorily aggravating factor. So this is a fair bit of booze. I'm going to be consuming some beer during the course of this, but I'm not going to get up to 160 milligrams of alcohol per 100 milliliters of blood. So Jobidon, a young, fit, and powerful man, had also been drinking beer prior to the fight, but in the opinion of the trial judge was not inebriated. The two men initiated their aggression in the bar of the hotel. With his brother and a few friends, Haggart was celebrating his impending marriage. So you can already see the tragedy working out here. He's about to get married. He's having a celebration. This is supposed to be a happy day. And he approached Jobidon, who was also in the hotel with friends, and started a fight with him. So it appears that Haggart was the aggressor here. He's the one who picks the fight. Haggart was larger than the appellant and had previous training as a boxer. So he's the bigger guy. He's got training. He figures he's going to win. He's looking for somebody to lay a beating on, is what it seems like from this. So that's sort of how this starts. In this first encounter, Haggart was prevailing when the owner of the hotel separated the combatants and told Jobidon and his brother to leave the hotel. Jobidon and Haggart exchanged angry words in the lobby, and the trial judge found that the two men agreed the fight was not over. Jobidon and his brother waited outside in the parking lot. When the Haggart party exited the hotel, their respective older brothers began fighting at the far end of the lot. Jobidon and Haggart argued. A crowd of people, many of whom had come outside to see the fight, gathered around them. Now, you can see here, this is how tragedies tend to happen. These two guys are spoiling for a fight, and, Jobidon might not have been the initial guy to sort of want this fight, but he could have walked away. At the end of the day, when he's waiting outside in the parking lot, he could have just gone home. And I will bet you anything that Jobidon, at the end of this, wishes he went home. So sometimes you might lose face by walking away and not winning the fight, but it can be a better call. So a crowd of people, many of whom had come outside to see the fight, gathered around them. You can imagine the people sort of chanting, fight, fight, fight. This sounds like high school to me. While Haggart and Jobidon stood facing each other, Jobidon struck Haggart with his fist, hitting him with great force on the head and face. Haggart was knocked backwards onto the hood of a car. The trial judge determined that Haggart was rendered unconscious by this initial punch and that he appeared to be out cold. He was not moving and offered no resistance to the appellant. Immediately after throwing that first punch, Jobidon continued forward. In a brief flurry lasting no more than a few seconds, he struck the unconscious victim a further 4 to 6 times on the head. The trial judge found that there was no interval between Haggart's fall and the continued punching. The punches were part of one single continuous transaction, one fluid event, punctuated by specific blows. The judge noted that the most reliable witness testified that it all happened so quickly, he thought Haggart would bounce off the hood and resume the fight. That's not what happens. Instead, Haggart rolled off the hood and lay limp. He was taken to the hospital in a coma where he died of severe contusions to the head. I bet he wishes he hadn't got into it. Well, he doesn't wish anything, but if you gave him if he had the sort of foresight to see what would have happened here, would he have gotten into this fight? If you knew that this was going to be the result? Anyway, medical evidence showed that he had sustained extensive bruising and abrasions to the head and neck. It was determined that the cause of death was one or more of the punches he had received at the hand of the appellant in the parking lot. The trial judge found that Jobidon did not intend to kill Haggart, nor did he intend to cause the deceased serious bodily harm. However, the possibility of injury more serious than a bruise or bloody nose, such as a broken nose, was contemplated. Jobidon intentionally hit Haggart as hard as he could, but believed he was fighting fair. He did not depart intentionally from the kind of fight that Haggart had consented to. Jobidon believed that Haggart had consented to a fair fight, the object of which was to hit the other man as hard as physically possible until that person gave up or retreated. The trial judge also found that, although mistaken and not supported by objective facts, Jobidon honestly believed that after Haggart had been struck onto the hood of the car, he was merely stunned, but still capable of fighting back and still trying to fight. If we see this as being, a very fast, continuous action, which the witness sort of described, it seemed like he was just sort of following up. He thought he was pressing the advantage, and really the guy was dead either maybe after the first hit. It's hard to know that, but certainly by the end of it. So Jobidon was tried before a judge of the Supreme Court of Ontario and was found not guilty of manslaughter. The judge held that Haggart's consent negated assault and held further that Jobidon had not been criminally negligent. The respondent appealed the judge's holding of assault to the Ontario Court of Appeal, which allowed the appeal, set aside the acquittal, and substituted a guilty verdict on the charge of manslaughter. So here what's happening is because that assault or that criminal negligence is required for the manslaughter conviction, and consent is an element, the lack of consent is an element to the assault. If Jobidon can win if Jobidon can establish that this was a consensual fight, that they both agreed to it, that cancels out the assault, which then cancels out the manslaughter. But you can see here, this is a tragic scenario. This is really sad. This guy was, he's all set to get married, and they have this stupid fight, and he ends up dead. This is the sort of thing that pulls on the heartstrings, and it tends sometimes to lead the courts to make decisions that, in my view, are bad decisions. And I think this is one of them. So let's continue on, and we'll see sort of what I'm talking about here. So the judge characterized the legal issue before him as whether the consent of the deceased to a fair fist fight provides a defense for the accused. He noted that in England, consent does not provide a defense to a charge of assault. So in England, you can't consent to a fight. Here in Canada, you can, with some real provisos, and those provisos are actually really hard to follow because of this case. So yet, after reviewing the case law, referring to both English and Canadian authorities, he concluded that he was bound by the decision of the Court of Appeal in Ontario in the Queen and Dix from 1972, which is no longer good law because Jobidon overturns it, which held that the defense of consent applies to fistfights. Thus, he defined the only material issue before him to be whether the accused went beyond the bounds of the consent. And an example of going beyond the bounds of the consent is, let's say you and somebody decide you're going to have a fist fight, and you're trading blows, and somebody is getting upset because they're getting the worst of it, and they pull a knife and stab the other person. That would be an example of going beyond the bounds of the consent because nobody consented to knives, but suddenly this person pulled a knife. But they say here, given his finding that the appellant had neither intentionally nor factually exceeded the scope of the deceased's consent, in part because the shouts from the crowd that it was a fair fight bolstered the evidence of the accused, he held that there had been no assault. Therefore, the appellant was not guilty of manslaughter. Now, the Ontario Court of Appeal has a different view. In a unanimous decision, 5 judges of the Ontario Court of Appeal overturned the trial judge's determination, substituting a verdict of guilty on the charge of manslaughter. The court disagreed with the trial judge's interpretation of the role of consent in the offense of assault. It concluded that, primarily for reasons of public policy, there are limitations on the extent of harmful conduct to which one may validly consent and thereby bar conviction for assault. The Court of Appeal held that the applicable limitations on consent are those described in the decision of the English Court of Appeal, Criminal Division, in Attorney General's reference, etc. Now, here's the problem that we get to. Public policy is something that the courts are, in my view, terrible at. The courts don't have a very broad view of public policy. The courts don't have access to, committees. They don't have access to research and fact-finding and various other sort of things that we would expect from a policymaker. Those things are typically the realm of what we have for Parliament makes those decisions. Parliament will have access to those details, and Parliament will typically, sorry, I'm messing with my brightness because it looked a little dark in here. So that's a reason why typically the court doesn't want to step into the role of lawmaking. Unfortunately, that seems to be exactly what they're doing here, where they say that they're going to make a decision for public policy reasons. It's very difficult, in my view, to say that that's going to be something that's justified. Normally, the court shies away very strongly from those kinds of decisions. So I have concerns whenever the court starts weighing in as to public policy. I find that this is often a rationalization that comes up where the court makes these kinds of bad decisions that feel like they're justified by the heart more than by the head. So they note that they say, it is not in the public interest that people should try to cause or should cause each other actual bodily harm for no good reason. Minor struggles are another matter. So in our judgment, it is immaterial whether the act occurs in private or in public. It is an assault if actual bodily harm is intended and/or caused. This means that most fights will be unlawful regardless of consent. It also explicitly concluded that the Queen and Dix, which had accepted that absence of consent was a material element to the offense to be proved by the Crown, was wrongly decided. Okay. So the appeals court finds that since the trial judge found that Jobidon had intended to cause bodily harm and in fact caused death, the Court of Appeal held that the Crown was not obliged to prove absence of consent. Therefore, since an unlawful act of assault had been committed and had resulted in death, the element of manslaughter had been made out, and the Crown's appeal of the acquittal was allowed. So essentially, consent vanishes from the definition of assault because there was an intention to cause bodily harm. So the court is going to go and look at this in some more detail here. Let's have a look at how they do that. So the appellant argues that the court should have accorded full effect to Haggart's consent, as was apparently required by Section 265(1)(a) of the Criminal Code, which states that an assault occurs when, without the consent of another person, he applies force intentionally to that other person, directly or indirectly. Now, keep in mind, this is an old decision. I believe that this has changed somewhat. Section 265 sub 2 provides that this section applies to all forms of assault, including some types I'm not going to mention because YouTube will get upset, threats to a third party or causing bodily harm, and another type I'm not going to quote. In the appellant's opinion, the trial judge's finding of consent meant that all the elements of the offense of assault had not been proved. The appellant should therefore have been acquitted on that basis, since the legislature intended that consent should serve as a bar to conviction. Now, if you think about this, this is essentially saying that you are adults, you're, fully grown, you're in control of yourself, you can consent to make bad decisions. And getting into this fight was clearly a bad decision for at least one side, and it could have gone either way. If you look at this, the deceased was not actually a small, it's not like a small person who wasn't keen on the fight and who didn't have any training. In fact, they noted that he'd been a boxer. This is somebody who could easily have prevailed, and this could easily have been, the reverse. So that's sort of the consent view on this. They note, according to the appellant, the legislature could have specified that in certain situations, or in respect of certain forms of conduct, absence of consent would not be an operative element of the offense. It has done so with other offenses. Parliament has provided that no person is entitled to consent to have death inflicted upon them. It restricted the concept in sections 150 and 159 of the Code by denying defenses to certain offenses involving children based on the children's consent. It also did this in section 286 by negating the validity of a young person's consent to abduction. So what they're doing here is they're saying because Parliament specifically removed consent from those other circumstances, we can conclude that they meant for consent to be a full defense in this particular one where they didn't choose to do so. They say, but with the assault provisions in 265, it chose not to insert policy-based limitations on the role of consent. And again, Parliament is where policy decisions should be coming from, not the courts. The courts are not supposed to be lawmakers. So moreover, in 265 sub 3, Parliament expressly specified the circumstances in which consent would be vitiated on the grounds of involuntariness, but the circumstances described in that subsection do not include the policy limitations applied to fistfights by the English Court of Appeal. And they noted that in England, the crime of assault is not defined in a criminal code, but in the common law, to which common law limitations and exceptions more naturally apply. In Canada, we have a code of general principles by which it is presumed ambiguity is to be construed in favor of the liberty of the subject. And almost entirely, common law offenses have almost exclusively been eliminated in Canada. So, and what that means is that if you're committing a crime, it should be something that's found in the criminal code. Or if you're breaking the law in some other fashion, it should be written down somewhere. Finally, the appellant argued that the Court of Appeal did not appropriately characterize the Canadian common law. In its opinion, the Canadian jurisprudence shows that one can effectively consent to the application of force in a fistfight, even if bodily harm was intended and caused. Again, relying on that previous Dix decision. So the Crown has a different position on this. They say, and their arguments are the Court of Appeal's arguments, they say that the overwhelming weight of common law authority supports the position that one cannot validly consent to intentionally cause bodily harm in all circumstances, and that the law prohibits consent to street brawls or fistfights. It is not in the public interest that people should engage in these sorts of activities, and so, on public policy grounds, the word consent in section 265 should be read in light of the common law, which limits its applicability as a defense to assault. The Crown also noted that fist fighting is without social value and has been outlawed in other common law jurisdictions. Now let's stop here and have a think about this, because without social value, well, right about now, it's about 1:25 in the morning. I'm enjoying a beer. I'm not, this isn't a social event. Of course, the current situation has kind of limited social events. I don't know how much social value there is in me enjoying a beer, but I certainly am enjoying it. A lot of the things that we do don't necessarily have a lot of social value. If I sit back and read, I have, I just got a book, beginning Cree. I'm trying to learn a little bit. I am not very good. I haven't gotten very far. I don't know how much social value there is in that. It's got value to me. It's something I want to do, and that's it. Most of the things we do don't have social value in this sense. But when we start getting into limiting what people can do and what they can choose to do, that, to my mind, inherently has social detriment when we start telling people what they can and can't do. So this rubs me the wrong way. I don't like this reasoning at all. The respondent further submitted that Parliament did not intend to oust the common law limitations on consent. If they had so intended, it would have made that intention far clearer. There exists an established interpretive principle that the legislature does not intend to make substantial changes in the existing law beyond that which is expressly stated in or follows by necessary implication from the statute's language. Now, to my mind, when you specifically say that you are allowing for certain limitations and then you leave it blank that you're or as to others, that's a necessary implication. But again, this isn't how the court's going to go. Thus, since the statute says nothing about common law limitations being erased, one should presume they were left intact. The respondent argues that in the alternative, so if the court doesn't agree with that, they still want a conviction. They say that the appeal should nevertheless be dismissed because Jobidon caused the death of Haggart through the unlawful act of causing a disturbance by fighting. Now think about that. The actual disturbance isn't what caused Haggart's death in any fashion. It's the fight. So I don't know about this this one seems like a bit of a stretch. So let's have a look at some quotes here. I'm going to try to keep this video from becoming too long, but let's have a look at how the court goes. So the Supreme Court also notes, by that wording, once the trial judge found that the deceased had consented to a fight with Jobidon, it appears that he could not have committed the unlawful act of assault, since 265 sub 2, again the section on assault as it was at the time, specifies that it applies to all forms of assault, including assault causing bodily harm. Consequently, given the reference to absence of consent, proof of consent to a fist fight in which force is intentionally applied and which results in bodily harm would seem to serve as a defense for Jobidon. In that way, those sections also appear to support the appellant's position that absence of consent is a requirement to be proved by the Crown beyond a reasonable doubt in each and every instance of assault. They say, given the prima facie appearance of support for the appellant's position, one might question how the Ontario Court of Appeal could hold that the deceased's consent to a fair fight did not preclude commission of the offense of assault. So we can see here they're saying, at first blush, the appellant's, Mr. Jobidon's position looks good. They say that question would be well aimed. Provincial courts of appeal have grappled with the issue on numerous occasions in recent years, sometimes arriving at divergent conclusions. They say, as regards the present law, it is clear that sometimes, as in the case of mere touching, consent is a defense, and that in general, where the contact is intended to cause death or serious harm, consent is no defense. It is also clear that even in circumstances going beyond mere touching, for example, in surgical operations and in lawful sports, consent can prevent the force from being unlawful. What is unclear is the extent to which the same rule applies or does not apply in Canada outside the operating theater and the sports arena. For example, in sadomasochistic circumstances. It is the purpose of the remaining analysis to clarify the role of consent in relation to a fist fight or brawl. Now, let's have a look and a little bit of a think here, because this is a 1991 decision of the Supreme Court of Canada. In the past 30 years, views on, for example, sadomasochistic circumstances, I would suggest have probably evolved quite a bit, such that a recognition in terms of the public interest might have changed quite a bit. I suspect that there's a lot more notion of maybe we should stay out of people's business for those circumstances, rather than should we decide if there's a public interest in how two particular people are engaging in their private affairs. I think that this case kind of ages itself in this particular line here, because it's very difficult, in my view, to see how what they're suggesting is an issue here should be an issue anymore. Continuing on, they say Parliament could have specified whether the term consent is aimed simply at the kind of activity being purportedly consented to here, a fist fight, or whether it refers to consent to a trivial injury which does not amount to bodily harm, such as might be sustained in sporting activities, or whether the defense apply the consent must be as to the precise extent of harm actually caused by the application of force. At any point in the history of the provision, Parliament could have taken the opportunity to specify whether the common law, which already had had much to say about assault and the requirement of consent, was being emptied of relevance. But it did not do these things, nor did it have to. So they're saying that because Parliament didn't explicitly extinguish the common law, that the common law applies. Now, they're going to go through a tremendous amount of history here, and if you're curious about this, I recommend reading the case, but you can see just how much history we are not going through right now because there's just not enough time here. Now, I'm just jumping ahead a bit to where the Supreme Court is reviewing another decision, and in that other decision, the court had said, if anger or the intention to do corporal hurt or to truly injure or to cause actual bodily harm is to trigger the intervention of public policy and so nullify consent, it is difficult to imagine the case in which there would be no such intervention. Schoolboys in disagreement, with or without boxing gloves, intend and strive mightily to cause to injury or cause bodily harm. They are certainly angry. Even professional boxers fighting for money may not be able to resist the onset of a certain caller. So anger, very archaic language here. The contestants in fights in hockey or football also meet all the criteria. The friendly fight is a rare phenomenon. Indeed, if you're getting into a fight, you're probably angry. The express tests do not, in my respectful opinion, focus on one of the elements which should even more quickly induce the public policy of the law to nullify consent. The fact that in most fist fights, challengers are often large trained bullies and the genuine consent of the other person is dubious at best. So they rejected those tests, and they noted that they said it would be difficult and bordering on judicial usurpation of political authority, which is what I've been saying here, to formulate a code for tests for nullifying the consent of weaponless fighters based on anger or intent to cause bodily harm. Thus, even though it disagreed with the trial judge's factual findings of consent, the Court of Appeal regretfully dismissed the Crown's appeal. Provincial appellate courts have thrice been asked to interpret the role of consent in assault-based offenses after the particular case here. So we can see again, there's a problem here in terms of the public policy issue. So I'm just skipping ahead here to discuss a bit of the result. So what the court finally lands on. And they say that the limitation that applies is to vitiate consent, which means to cancel the consent. It's not valid. Between adults who intentionally apply force causing serious hurt or non-trivial bodily harm to each other in the course of a fist fight or a brawl. So what you can end up with is people who get into a fist fight, and depending on how the fist fight actually works out is whether or not that consent was valid. I don't like that. I don't really like that as reasoning, because surely people should know whether their consent is valid from the outset. You know, is it valid for us to undertake the activity that we're about to undertake? And you don't need to wait for the results of it. It's like saying that it's okay to play the lottery so long as you win. I don't really understand how this makes a whole lot of sense. But let's continue, because the court is going to do something that in my view is a much more serious transgression, which is that they set out this general rule and then they start having to carve holes in it. They say, but this exception applies, and but this other exception applies, and but. And whenever you've got a general rule that you have to start carving more and more holes into, and sometimes vague and undefined holes, it's probably just that your general rule wasn't that good to start with. So let's have a look at some of what they're doing here. They're saying, stated in this way, the policy of the common law will not affect the validity or effectiveness of freely given consent to participate in rough sporting activities, so long as the intentional application of force to which one consents are within the customary norms and rules of the game. Unlike fistfights, sporting activities and games usually have a significant social value. They are worthwhile. In this regard, the holding of the Saskatchewan Court of Appeal, and they cite Queen and Kay. Now, if we think about some sports, mixed martial arts or boxing, the goal is basically to intentionally apply force to somebody repeatedly until they give up or the rules prevent them from continuing. But in many cases, you're talking about people suffering, substantial injuries. Boxers may be knocked out in the course of a boxing match. And if you watch interviews with old boxers, a lot of them you can kind of tell that they've suffered a lot of concussions over their career because maybe they're not all there, some of them. You watch... Heck, I watched an arm wrestling tournament, and the number of broken arms you see during that is not small. So is it kind of weird to say that these guys could have gotten into a fight if they were in an MMA ring, but because they're in a parking lot, the parking lot somehow makes it illegal? I have trouble with this. It just does not make sense to me. You can let me know in the comments below if you think this makes sense to you. So they say that some forms will clearly fall within the scope of the rules of the game, and therefore ground a finding of implied consent, to which effect should be given. However, if we think about this, these two probably understood that there were rules of the game in this fight. Sort of customary norms of getting into a barroom brawl. They're allowed to, to swing fists at each other, but certainly I don't think either of them would have viewed it as a fair fight if one of them had pulled a knife, or if one of them had picked up a rock, or if one of them had secretly slipped on a pair of brass knuckles. That would have been a deviation from their understanding of the rules. So both settings have rules. Just one is rules in a manual, and the other is rules sort of understood by customary norms of conduct. And you might say, well, customary norms of conduct don't get us very far. But that's exactly what the court's relying on here, is customary norms, essentially. Continuing on. They say there's also nothing in the preceding formulation which would prevent a person from consenting to medical treatment or appropriate surgical interventions. Nor, for example, would it necessarily nullify consent between stuntmen who agree to in advance to perform risky sparring or daredevil activities in the creation of a socially valuable cultural product. So when we think about, like, Jackass, the guys doing various things to each other, I guess that's a socially valuable cultural product. I mean, they made a lot of money. I'm not judging them in the sense that, they produced something that was enjoyed by many people. But whether that's socially valuable as a cultural product is really something that is a subjective notion. I don't terribly enjoy watching that. No judgment if you do, but that's not my thing. It seems like it starts to matter whether it's the court's thing as to what you're doing. So they say a charge of assault would be barred if the Crown failed to prove absence of consent in these situations, and insofar as the activities have a positive social value and the intent of the actors is to produce a social benefit for the good of the people involved and often for a wider group of people as well. This is a far cry from the situation presented in this appeal, where Jobidon's sole objective was to strike the deceased as hard as he physically could until his opponent either gave up or retreated. Fistfights are worlds apart from these other forms of conduct. Now, let's stop here and think about some other forms of conduct that we might need to consider. Let's consider you go and get a tattoo or a piercing. What is the positive social value? Well, the positive social value is to the person getting the item, because presumably, if you're going for a tattoo, you want the tattoo. Presumably that's something you are choosing to do. Now, if you attacked somebody in a way that caused a permanent mark, the court would have no problem in finding that that was a non-trivial bodily injury. If you held somebody down and physically tattooed them, they wouldn't have any problem with saying, hey, that's a bodily harm right there. But the social benefit is just you have been able to choose this. It's a part of who you are as a person. It reflects your personality. It reflects your drives. It reflects your interests in life. So do we really need to see that the court decides that this decision has positive social value? I have problems with this. How do we decide what this positive social value is? Is it that other people agree with you? What happens if you're going to get a really bad tattoo? Let's say you are, let's say you're going to get something tattooed on your face, and it's something that's offensive to the vast majority of people. And so this tattoo is going to prevent you from holding down gainful employment. It's going to make you a pariah in the views of people who see you. Isn't it still your choice? Isn't that still your call? It might be a bad choice. It might be a terrible life decision. But we can make terrible life decisions all the time. If I want to cash out my RRSPs and spend it entirely buying dry ice and watching it evaporate in the backyard, I'm entitled to do that, even if there's no positive social benefit. I find that the reasoning here is very difficult to extend into other scenarios. And to my mind, good judicial reasoning should be such that you don't need all these exceptions and all of these sort of thinly reasoned exceptions, in my view. And you don't need to, and it's something that should have broad general applicability. The rule shouldn't just apply to fist fights. But if we're talking about positive social value, that seems to me to be a rule that we apply to almost nowhere else in life. If I go to my banker and say, I would like to take out my money because I want to buy dry ice to watch it evaporate in my backyard, the banker has my consent to close out my accounts and give me the money. Whereas if the banker closed out my accounts and took the money and, so forth without my consent, that would be a very serious thing. There's no social benefit to it. There's literally nothing. Everyone involved is harmed, except perhaps the guy selling the dry ice. He's having a good day. So I don't like this reasoning. I think that Jobidon is a terrible decision. And when I say that it's a terrible decision, it's a decision that has had impacts down the line. You get people who think that they're both agreeing to something, and where they're, unfortunately, the court later says, no, you're not. In particular, this sort of reasoning has been used both in the UK in the decision of Brown, and also here in Canada, there's the decision Welch, which has been used against people with sort of unusual sexual practices. And so the courts have applied this kind of reasoning to say, notwithstanding the fact that you guys thought you were consenting, no, you weren't. And that's because your particular practices, what you enjoy, is of no social value. And my thought is, to the court on something like that, comes down to something like, how dare you? But that's the case of Jobidon. It is, unfortunately, solid law. There's lots of citations to this. I don't see it as being overturned anytime soon. I don't think Parliament is going to touch this one. But I think it's a terrible decision. I don't think it's easy to support. Now, I'll note that the dissent would have said, hey, listen, they consented. They agreed. So the dissent would have said, acquit here. Now, there's the possibility that if you overturn this, that people will make bad decisions. But I kind of measure freedom in how far you can go in making bad decisions that hurt yourself. Because otherwise, you've got a court that's sort of stepping in and playing parent to adults. So, and you might have people, saying things like, they want to do extreme things. They want to, I've seen pictures of people who've done things like, for instance, splitting their tongue. It's a fairly extreme body modification. I'm not sure what the public interest is in it. But at the same point, if somebody wants to do that to their tongue, to the extent that it's my business, is zero. It's not my business. That's their tongue. It's their call. It's, other people may choose how to react to them, and they may have consequences for making that decision. But there's consequences to making every decision. My personal view on this is that the court ought to have taken a view supporting expansive consent in the absence of some specific language from Parliament to the opposite. At any rate, that's my video on Jobidon. I hope you found it educational. If you have questions, please leave them in the comments below. If you enjoyed this video, please like the video. Please share it with your friends. Please subscribe to see more content. I'd like to thank $30 Patreon supporter Steve Browning, $50 Patreon supporters George and Demo, as well as all the $10 Patreon supporters in the crawl immediately following. Thank you for watching. I'll leave a link to the decision as well as to my Patreon below. Thank you, and I hope I've armed you with knowledge. Good night.